matter of the French state and the Kingdom of Spain and the London Steamship Owners Mutual Insurance Association.
Good morning, Mr. Young.
Good morning, my lord, my ladies. There is before you a host, a maelstrom of appeals and cross-appeals and respondents' notices, not to mention, is behind my lady, Lady Justice Andrews, and indeed around me, a whole host of physical bundles. See, your lordship is rather more up to date than you. I appear with Miss Naina Patel for the Kingdom of Spain. Anna Dilnot, King's Counsel, and Naomi Hart here for France. Mr. Hancock, King's Counsel, Mr. Delamere, King's Counsel, Mr. Alexander Thompson, who are currently here, appear for the club. They are going to be joined, I'm told, next week by Miss Charlotte Tan and Professor Philippa Webb. And then there's Miss Josephine Norris for the European Commission. So I think, my lord, the background of this case is so fully, not to say repetitiously, set out in the various judgments and skeletons supporting and opposing the relevant appeals that unless the court wants any particular points by way of clarification or assistance, I'm not going to waste the court's time by rehearsing them.
Can I just say a couple of things,
My lord.
Mr. Young? The court has done a very large amount of reading.
Hard luck.
And thinking. And we probably will hurry you along in some areas of the case and slow you down in other areas of the case. And it might be helpful if I were just to give you a little bit of a bird's eye view. The thing that troubles me most about this case is the absence of an agreed list of issues for the court to determine.
Yes.
And I have tried to put such a list together. I freely understand, having attempted that exercise, that why you haven't done it. But I would like to be clear at all stages of the argument what issue is being addressed, and to be sure that those issues are the subject of a notice of appeal or a respondent's notice. The next thing is this, that it does seem to me that the parties have got in their respective silos and dug very energetically throughout this litigation without necessarily thinking what is the outcome for which my side advocates, really, because there are so many inconsistencies and imponderables, and they may be created by others, but actually it's not an answer to say, well, the Court of Justice decision is difficult to understand, we have to deal with that very often. It's not an answer to say, well, this person did that thing wrong 7 years ago, and we're still digging in our hole and not really thinking about where the, I'm sorry, the analogy or the metaphor is getting stupid, where the mud's,
I'm happy with it,
where the mud is going. Or as my lady said to me this morning, worrying about whether the whole thing is going to collapse on my head as I continue to dig. So leaving
There is an element of the House of Cards about it all.
There is an element. And you both, you know, obviously have been involved in this ever since time began, and we have not. But those who know me will know that I'm very much in favour of practical, sensible outcomes for litigation. And at the moment, I'm going to need some help with that. Yes. And I would much appreciate both sides giving their mind to it. There's two other problems that really do trouble me. The one is the problem of the res judicata defences, various res res judicata and issue estoppels that arise in the context of the decision we have got from the Court of Justice. And the other is the question of equitable compensation. Because what is said by the club and the arbitrators is there is this broad, untrammeled principle whereby you just have to mention the word equitable compensation and you get it. And I freely understand the very interesting authorities in Authorities Bundle D, where certain members of our Supreme Court and academic writers indeed believe that we don't need to worry about where rights come from, but I do worry about where rights come from and how they can be properly vindicated and what is their extent. And I'm not saying that there's no such thing as a new species of equitable compensation, but I would like some help with how that is to be delimited and understood,
Yes.
and where it comes from, and what are its limits. So that, we've got 7 days. I think you've agreed 3 days for the Brussels case, 2 days for the, what you call the arbitration cases, and 2 days for the human rights cases. We don't think 2 days for the human rights cases would be time particularly well spent. So if anybody wanted to abbreviate that, we would be very happy. We've got the written arguments and can see what they amount to. We do think that there are some very difficult questions raised by the registration of this judgment in the light of the Court of Justice decision. And we do think there are some very difficult questions raised by the question of equitable compensation. But we've looked at 5 million cases cited and find them lacking in an answer. None of them, really, not a single one I've looked at really helps us that much. So diving into the facts of multiple decisions which actually result in thinking that the answer is a lemon might not help us. But obviously you will have to look at some of the cases and make sure we understand them. But other than that, Mr. Young, we are in your hands. I don't know either Lady Justice Andrews or Lady Justice Falk would like to add anything at this point. Good.
What I will say, my lord, is that what your lordship has just said is broadly in line with the way that I want to go about addressing the various points. So I'm sure I will fail lamentably, but I am in complete agreement with everything you said, except for one thing, that the judgment of the Court of Justice is difficult to understand. When you look at it in a sort of parsed way, as my learned friend Mr. Hancock does, it might be, but actually I'm going to try and show your lordship that it's rational and sensible. So if I can put my little...
Okay, and there's another sort of element that is not the subject of a notice to appeal, which is the quote-unquote sanctity of international arbitration.
Yes. Yes, it's more the accepted characteristic of arbitration, because as you will know, there is an express exception from the regulation and the recast.
Indeed, but you'll come to that. Let's not argue that point now.
No,
I want just to say 2 more things. There will be no breaks for transcript writers in this hearing, I regret to say. I never break. For transcript writers, they have something called a recording mechanism, which enables them to catch up later if they need to leave the court. I'm sorry about that, but that's the way we operate.
Can I just say it's a real-time case, so if I leave, the real-time will stop. Is that okay?
That's fine.
Thank you.
Because the important thing is not to lose momentum in the argument, and I'm afraid just breaking every hour is very nice in a trial, but it's not much use here. And that's really it. I assume you've got a sort of vague idea as to timetable.
We've got a very exact idea, I think.
Okay, well, I would urge you not to stick to it if sticking to it is going to deprive the court of assistance in the areas we've mentioned. And the other thing is, I hope your juniors are involved in making some of the submissions to us. We very much encourage that in this court.
All I can say, my lord, is that I was ahead of you on that one.
Good.
Albeit that human rights will not necessarily feature quite as strongly. All of the heavy lifting on human rights is going to be done by somebody who actually understands human rights, which is Miss Patel.
Right, excellent.
Who I hope will not remain on that bench for a great deal of time. But absolutely.
Good. Okay, over to you, Mr. Young. We will try and remain quiet, but as you know, the best laid intentions,
my lord,
sometimes fail.
To me, the great benefit of the system that we have is that there is an interchange between bench and bar, so that what interests the bench can actually be properly ventilated and addressed. So please, if I can ask any member of the court with a question, put it to me. If it puts me off my stride, well, that's tough. I can live with that. But I would welcome questions and interventions.
Thank you, Mr. Young.
My lord, my ladies, this case is in some quarters been depicted as the last great battle of Brexit, whereas in fact it is basically about the interpretation and application of half a dozen or so English or UK statutes. And it is only at one stage removed that one has to grapple with arguments about European jurisprudence and the boxes which surround me. So this is ineluctably in my submission a case about statutory interpretation. Now there are still lots of authorities and certainly in my recent experience a long period of time graciously given by the court, but in my submission the case can be summarised in 8 relatively short points, and if I can possibly, following from your lordship's question, if I can just identify them. The first point is that this court, as well as Mr Justice Butcher, is bound by UK statute, by international agreement, and by a Court of Appeal judgment to treat the judgment of the Court of Justice as binding on and in the United Kingdom in its entirety. It's on and in the United Kingdom since it becomes part of UK, English and Scottish and Northern Irish law, but it's also binding on the UK government. And it's not a curate's egg. It isn't good in parts and bad in parts, where the English court can sift through, deciding what it wishes to be bound by and what not. It's in its entirety means the Court of Justice judgment, both its dispositive paragraphs and its reasoning, are binding. And in a sense, that disposes of the enforcement appeal. The second point is that the Court of Justice has interpreted Articles 34.1 and 34.3 of the regulation which are exhaustive of the rights of a national court to refuse enforcement of a judgment of a member state court, and are to be restrictively interpreted and applied. So Article 34 does not permit of any other grounds for resisting enforcement other than those specified, and those specified have to be strictly construed. And that interpretation by the Court of Justice is expressly binding on this court, Mr. Justice Butcher, and in truth, dispositive of the dispute in the present case. And it certainly provides no lawful basis for resisting enforcement of the Spanish judgment. The third point is that no member state has the power to review the vires of the Court of Justice, still less to hold that the Court of Justice judgment is not binding, either in whole or in part. The English court is in no different position. The withdrawal agreement and the EU Withdrawal Act binds it to apply the Court of Justice judgment in its entirety, and that renders consideration of whether there was or was not an excess of jurisdiction by the Court of Justice entirely irrelevant. The fourth point is that there was in fact no excess of jurisdiction, since
There was no excess of jurisdiction.
Sorry, excess.
No excess.
No excess of jurisdiction at all.
So you've got a bit of competition outside, that's all.
Yeah, yes. The Court of Justice did no more than what it was there to do, which is to give the correct answer as a matter of EU law to the reference in a way that gives assistance to the referring court in the disposition of the case before it. It did exactly what it is supposed to do. And it did so by purposively interpreting Article 34, 1 and 3 in the context of the regulation as a whole, doing precisely what it was supposed to do, and doing indeed what any English national court would do with a statutory provision, look at it in the context of the entire statute or regulation. The fifth point is that there is and can be no pertinent public policy, in inverted commas, issue estoppel, since the issues before Mr. Justice Hamblin and the Court of Justice were entirely distinct and analytically different. The Court of Justice answered the question, is Mr. Justice Hamblin's Section 66 judgment a judgment within the meaning of Article 34.3 at all? Mr. Justice Hamblin answered a very different question. If if a Section 66 judgment is a judgment, would it be wrong to enter it? There being two very different...
Sorry, just say that again. Who asked whether it was a judgment within 34.3?
The Court of Justice of the European Union was asked, is a Section 66 judgment a judgment within 34.3 as being irreconcilable?
And then you said...
Mr. Justice Hamblin was concerned with whether it would be right to enter a Section 66 judgment at all.
As a matter of discretion.
As a matter of discretion. There are two quite different things. He said, is it right to enter the judgment? And then we'll have to look at what the learned judge's judgment said. And he concluded that because a Section 66 application was an arbitration application, the regulation was completely irrelevant. But that didn't mean to say that when push comes to shove and there is enforcement and you have a judgment, is it capable of being an irreconcilable judgment within the meaning of Article 34.3? That's a completely different question.
Yeah.
But I will come back to that in a bit more detail. The sixth point is that the award of Mr Schaff, which was what set everything running, especially once it was converted into a Section 66 judgment, gives no basis for holding that enforcement under the regulation should not be achieved. I think Mr Justice Butcher said it fell under the ambit of the public policy exception in Article 34.1. And one has then to have a manifest, that word is not unimportant, a manifest offence against national public policy to an unacceptable degree. And even then, what is meant by and embraced by public policy in Article 34.1 is not entirely a matter for the national court. It's a concept which has to be viewed within the limits of European Union law. So it's a narrower or potentially narrower concept in Article 34.1.
So you'll deal, obviously, with the suggestion that the Court of Justice did not say that there could be no issue estoppel created by the Schaff Award.
I'm going to deal with that, my lord.
And you'll deal with why it is not a manifest offence against English public policy to ignore arbitration which is outside the regulation.
I will deal with that, my lord, yes.
Yeah.
The seventh point, I hope this is identifying the issues at least, that the master's human rights have no relevance to the club's resistance of enforcement of the Spanish judgment, before whose courts the club persistently refused to appear and therefore did not...
Sorry, just say that again. The master's human rights have no relevance to the
club's resistance of enforcement.
Yes. And they refused to appear.
They refused to appear and take advantage of the rights to protect their position under Spanish law to the extent possible.
Which was a point relied on by the judge.
Yes, indeed. And in any event, the master's human rights have not been infringed, as the European Court of Human Rights has held. There is one wrinkle. There is a UN committee which has held a very discrete offence arising out of a UN instrument which has been ratified by the United Kingdom but not embodied into UK law. And there'll be a question there as to what impact that has on the club's resistance to enforcement. And then I turn to the arbitration appeal. And
you've only got one point left for that.
I have, yes. It may be that my last point has got two sub-points.
Oh.
The club's attempt to render enforcement of the Spanish judgment ineffective by way of use of an arbitration is contrary to the effectiveness principle. And there are two respects in which the damages awards made by Sir Peter Gross and Dame Elizabeth Gloucester are wrong in law. The first is that because of the interaction of Section 13 of the State Immunity Act and Section 48(5) of the Arbitration Act, there was no jurisdiction in either tribunal to grant an injunction or an order of specific performance, and therefore there is no entitlement to grant damages in lieu under what still lives by the name of Lord Cairns Act, although reenacted, of course, in Section 50.
I mean, that's a highly technical point, right?
It is a highly technical point, but one
because what you're really grappling with is the brave new world of the Supreme Court, enunciated in, by the Privy Council originally in broad idea, and then persons unknown, and the ability to basically, where there's a right, there's a remedy, right?
Yes. Where there's a right, there's a remedy, except where Parliament has determined otherwise. Right. And in Section 13 of the State Immunity Act, Parliament said states who do not agree to the power to grant injunction.
But I mean, I get it, but you're assuming the injunction is a necessary prerequisite to the award of damages or equitable compensation.
Under Section 50,
Under 50
it appears
it
to
is,
be so.
But 50 is not necessarily exhaustive.
Well, there is, of course, I see that is a matter to be debated. But Lord Cairns Act, Chancery Amendment Act, was passed specifically because the courts of equity did not have a sufficient monetary compensation jurisdiction. And Sir Hugh Cairns, as he then was, developed a jurisdiction in the courts of Chancery, enabling monetary compensation awards to be made in specific circumstances. And in nearly every circumstance, that will give the Court of Equity and then subsequent to the Judicature Act.
Mr. Hancock has recently regaled us with some textbooks written by some quite important people, namely Mr. Edelman and Lord Burrows and others, who think that all this is quite irrelevant to the appropriateness of remedies and damages where a wrong has been committed.
Mm.
Now, what I need help with is what precisely is the wrong here, and what is the extent of that theory, if legal theory it is?
Well, the wrong, it's
because what you're trying to do, if I may, on the premise that you get your judgment registered and enforce it, is to take advantage of a contract whilst accepting, as the Spanish court did, that there was one limit in that contract, namely $1 billion, but not accepting there was another limit to that contract, namely pay to be paid.
Yes, one does have to remember, one has to go back a little bit and say, well, unlike almost every other case where a nation state has a civil obligation, which would normally be in a contract with a specific clause, probably dealing with the rights power to grant injunctions. Here, until the judgment of Mr. Justice Hamblin, it wasn't even apparent that there was any relevant arbitration agreement binding the Kingdom of Spain. What Mr. Schaff's judgment did was to provide the embryonic instrument containing an arbitration agreement. As I say, in almost every other arbitration involving a state, there's going to be a contract under which the state has either personal...
But you submitted to the jurisdiction after Mr. Schaff's award.
Yes, we didn't submit to the jurisdiction of Mr. Schaff, which is a problem in terms of creation of an issue estoppel. We did submit to the jurisdiction of Mr. Justice Hamblin.
Yes.
That is certainly true.
And he decided that the arbitration clause did bind you.
Well, yes, he did. But that was until that stage. It was not clear that Spain. As I say, you've got to bear in mind that in 99 cases out of 100, particularly involving civil liability of states, they arise out of contracts which have arbitration clauses. So there is never any doubt. You could just look at a charter party, look at a power construction agreement, and there will be an agreement with an arbitration clause, usually excessively long. Here, there was no such arbitration agreement, and even the Court of Appeal back in 2015 accepted the proposition that there was no arbitration contract. There was a deemed arbitration agreement arising under Section 80 of the Arbitration Act because of the exquisitely English conditional benefit principle.
Exquisitely English.
Well, I don't know that I don't know that it arises in many jurisdictions.
Well, whether it does or not, it has a certain amount of common sense justice to it.
I agree.
That if somebody enters into a contract that they will pay $1 billion in certain circumstances,
Those circumstances have got to exist.
and you try and take advantage of it and get the $1 billion, it might be said that you have to accept what the contract said.
I see the force of that, my lord. What one has to bear in mind is that rights of direct action under the regulation are against insurers, and the particular terms of insurance policies, which are the basis for direct action, are not necessarily to be available to the insurer as against the wronged, injured party. But also...
I'm not sure I understood that.
Well,
can you say it again more
yes.
clearly?
Let's take the simple case of a jurisdiction agreement in an insurance policy.
Yeah.
The insurer has, in his insurance policy, he has an exclusive jurisdiction clause for his own jurisdiction. That is not binding upon a direct action claimant by an injured party. That is not binding, and that's been decided by the Court of Justice in Assenshaven and by the Supreme Court in the Atlantic Confidence. So that part of the contract, if you like, the policy, is unavailable. The pay-to-be-paid provision may or may not be. In fact, it was available to be relied upon by the club in the direct action in Spain, but they eschewed, or it eschewed, the right to make representations.
So let's get this straight. You say that the club could have relied on the pay to be paid in the Spanish proceedings, but did not, and thereby loses the right to rely upon it again.
Yes, pay to be paid is a defence. We are not liable because the only person to whom we are liable is the ship owner, who has to discharge the
That's an interesting way of looking at it. Pay to be paid is part of the underlying conditions and terms of the contract. The basic principle is, unless you pay, I'm not liable. It's not a defence.
Yes, absolutely.
It's a fundamental part of the insurance agreement.
Yes, it's not really. It's not, in one sense, it's not a liability insurance at all.
No, it's as much a fundamental term of the agreement as the $1 billion limit on it, Mr. Young.
I wouldn't disagree with that, my lady. But and one goes back to the judgment of the House of Lords and the Fanti.
Yeah.
I'm not in any
Well,
way
that in
going
mind.
to dispute that. But there is a question as to when a direct action is commenced by an injured party, what defences are available to the insurer, and if he doesn't take them, what are the consequences? Now, the Spanish court held if they don't turn up and raise their defences, they have only themselves to blame.
Well, that depends on whether you're characterising it correctly as a defence. And the other way of putting it is, what does the person who's claiming directly against the insurer have to show?
And that would be a matter, ultimately, before the Spanish court. I would
Matter of
completely
English law, isn't it?
And the Spanish court has arrived at the conclusion, right or wrong, in the absence of the club, that the club is liable as an insurer under the insurance provisions of the regulation. I am, my lady, I'm not in any way suggesting that if the club had turned up and this were wholly a matter for English law, that the result would not have been relatively clear. But in a direct action brought under criminal injuries compensation provisions under the law of Spain before the Spanish courts, where the club did not even deign to appear and make representations, then there could be the consequence that the Spanish court regards the insurance as being within the insurance provisions of the regulation and thus give judgment.
So this is a very interesting submission. We're going to have to see where it fits into the rest of the argument, as I understand it. But I'd like to take you back to your 8th point.
Yes.
Because there were two ways, you said, in which the arbitrators were wrong. The first was the interaction of Section 13 and 48.5, because there was no jurisdiction to grant SP or
Second is
injunction, blah, blah. Chancery courts didn't have sufficient jurisdiction. That gave rise to Lord Kenzak. What was the second way they were wrong?
Equitable compensation.
That's just straightforward, wrong to grant equitable, or wrong to say that equitable compensation was available?
Yes.
And you will show us, will you, why, you know, what I call the new law, the new wind of change created by Lord Leggett and Lord Burrows and Lord Hamblin, etc., makes that clear as a matter of law binding on us.
Yes. Well, the way I would put it, my lord, is that Miss Dilnot will be bearing the heavy burden on the arbitration appeal because France and Spain have common cause. But I would say this. Sorry?
Because of her chancery background, I imagine.
Because she's so much better than I am. And her yes. The premise.
She can still remember it, actually.
Yeah. I wish I could. The premise of Lord Cairns' Act was that the courts of chancery, courts of equity, did not have the power to grant wide-ranging equitable compensation. It was limited, as I think Lord David Richards.
Yes, but that was
said it.
then. We're here now.
I agree it was then, but having been reenacted in 1981 in substantially identical terms, the premise is still the same, that equity has not got a free range on equitable compensation. Now, it may very well be that Lord Leggatt and Lord Burroughs get their undoubted intellects around this at some stage and will make new law. But I do say that Parliament, by legislating Section 50, has worked entirely upon the unstated premise that the breadth of equitable compensation needs extending. Or to put it another way, if equitable compensation is as wide as the new broom might have it, then Section 50 is not only misconceived, but it's also irrelevant.
But what I'm trying to fit in is your, what I put in my note here is a key submission, that pay to be paid was available to be relied upon by the club in the Spanish proceedings, but since they didn't, it's tough, they lose it. Now that comes in, does it, when we consider the breadth of the right to equitable compensation, because you would say, well, even if there was a wrong in seeking to take advantage of the policy without adhering to its terms.
Taking advantage of the regulation, which, yes.
Well, even if there was something, a right that arose against Spain, that right could only be vindicated within the Spanish proceedings by defending the Spanish claim, which was validly brought under the regulations.
It was validly brought under the regulation and indeed under Spanish criminal penal law, Article 117.
So you would say, however broad, even, I mean, I'm just trying to understand, but you would say, however broad the right to equitable even if there were a broad right to equitable compensation, it was compromised by the failure to defend.
It was compromised by that, and also by the effectiveness principle being...
which is a principle of EU law.
Which is a principle of EU law that when one is looking at enforcement of a member state judgment, it has not got to be rendered ineffective by a national rule. And we would say that the neutralization, the neutering of the remedy was contrary to the effectiveness principle. So, which is, it's not the same point, but it is yet another point that has to be brought in mind, brought into account when one is considering whether equitable compensation is indeed equitable and appropriate. But one of the points that I'm sure the court will be well aware of, and I have yet to show you the regulation, is Article 36 of the regulation.
Just give me 2 seconds.
Sorry, yes,
just to write down what you've just said.
I wonder if you'll give me 2 ticks to...
Yeah.
Article 36 of the regulation, as I'll show you in just a moment, says, under no circumstances can the substance of the incoming judgment be reviewed. So for the purposes of enforcement, you, as the enforcing court or the recognising court, cannot look at the substance and decide for yourself whether it was right or wrong, whether points were or were not taken. And it's not impossible to conceive, as I'm sure my Lady Justice Andrews will remember, that there are various ways round the pay-to-be-paid clause. One of the ways that was, I think, devised by a very eminent Chancery judge, and I can't remember which one it was at the moment, was it Lord Oliver, was that a loan was made by the injured party to the club member, who would then repay discharge the liability, and thus, in effect, create the payment plus an assignment of the right of action under the club rules. Now, that was one way round. That was then counteracted by most of the clubs, I think the London Club as well, by saying, you can't do that. You can't do it by way of loan. Fine. But what it didn't say...
Your clause says you can't.
Well, our clause says we can't. Can't do it like that. But that's only a loan. What happens if there is a contract, perfectly legitimate contract, by which the state pays $1 billion to the ship owner by way of a letter of credit with conditions attached, and then the ship owner then pays off the debt, or pays off the obligation to the state. And as the consideration for that payment is the assignment of the right of action under the club rules. Now, that is not a loan, that is purchasing the right of action. And you can resolve the problem, the practical problem that the ship owners might run off just by having payment by way of a letter of credit, which is only pays on presentation of...
Yes. I mean, I remember some litigation I was involved in for about 3 years in the 90s on this very subject. But can we just come back to the key point, which I'd not understood from the written arguments? So where is it in your skeleton or in your the particular grounds of appeal that you're placing so much emphasis on the failure to defend the Spanish proceedings on the basis of the pay-to-be-paid? That seems quite a critical point.
My lord...
And so it forecloses...
Yes.
The ability to be
well,
able
I say
to rely on that in any other context.
I don't say that it forecloses. What I do say is that it's something which has to be brought into the court's assessment of whether equitable compensation is available. I say, I'm
struggling with that, Mr. Young, because just to get my head around the concept, I can't see how that comes into the question of whether there's a wrong, or a right, which is the foundation of the right to equitable compensation.
Yes, I see that, my lady. The wrong is allegedly by acting in breach of the equitable obligation to bring proceedings only by way of London arbitration.
Yes.
That wrong generated no loss to the club unless and until the Spanish court gave judgment. The Spanish judgment was the result of the club not raising the pay-to-be-paid argument as a condition of Spain's entitlement.
That assumes they'd have won in Spain.
Which they did.
But doesn't it also assume that they should engage in the Spanish proceedings, whereas the London arbitration had confirmed the club's position.
The London arbitration merely confirmed that they had the right to rely upon the arbitration clause in Spain. One of the issues that developed at the trial was the point in time at which an effective the club could effectively avail itself of the right to rely upon the arbitration agreement as had been found to exist by Mr. Justice Hamlin and by the Court of Appeal. And it was said that it was too late, that if you wanted to make an application, then you had to make it at an earlier stage. Now, if I can put it this way, my lady. Parties A and B have a contract, straightforward contract, no bells and whistles of conditional benefit or the like, and it contains an arbitration clause. And A sues B before the courts. B has the right to seek a stay under Section 9 of the Arbitration Act. If he does not make that application, then the judicial proceedings will continue. Or if he takes a step in the action, a step in the proceedings, then he loses the right to obtain that stay under the Arbitration Act. If the analysis of the arbitrators were correct, then even in the case where a defendant, in the example that I've given your ladyship, doesn't successfully avail himself of the right to a stay under the English statute, he has still got a cause of action for breach of the obligation to arbitrate. So he can go through the entire court, he can lose all the way, he can submit to the jurisdiction, then he can say, I know I can't have a stay, but you, claimant, have breached an equitable obligation, and therefore I'm going to recover damages which are going to defeat completely the judgment of the English court.
Because none of what he's done wipes out the fact that there's already been a breach of the arbitration clause, and unless he's waived his rights under the to claim compensation for the breach, it seems to me that there's nothing wrong in principle with that analysis. Absolutely right, but the statute prescribes how the waiver can come about. Yeah. So leaving aside waiver for the moment, you say, oh, this is all absolutely horrific. You know, he's submitted to the jurisdiction, he's failed to ask for a stay, etc., etc., etc. None of that affects the fact that historically there has been a flouting of the arbitration clause. Correct. There's been a breach. Correct. And once there is a breach, there is a right to claim damages unless you waived it. Correct. And so...
My point goes further. On the facts of this case, it wasn't simply a failure to participate. There was an active reference to London arbitration. It seems to me the chronology is relevant as well.
There was an active reference to London arbitration, but that was merely, in a sense, rendering concrete what would otherwise be the contract in the example that I've given your ladyship. And until Mr. Justice Hamlin gave judgment, or indeed the Court of Appeal, I think probably the Court of Appeal gave judgment, there was no definitive instrument containing an arbitration clause binding Spain at all. As I say, you've got to remember that this is the incredibly unusual example of a state being liable without a contract containing an arbitration.
Can I just clarify that last statement, because I don't understand it and it must be my fault.
Sure it isn't.
Until the Court of Appeal pronounced there was no definitive instrument.
No, there was no definitive instrument binding Spain as effectively as a party to it.
Well, hang on. The Court of Appeal doesn't create an instrument.
No, it was the equivalent.
The Court of Appeal declares what the rights and obligations of the parties are. But the fact that the court has pronounced on it doesn't suddenly create those rights. They exist. And the court simply tells you what they are.
Yes, I'm sorry, my lady. I've not made myself as clear as I would have liked.
No.
In nearly every case, there will be a contract binding a state to an arbitration clause, and possibly, usually, to an arbitration clause which includes the power to grant injunctive relief. In this case, there was no such instrument. There was no such instrument signed up to by Spain. The arbitration agreement, which was generated on the application of Section 80 of the Arbitration Act in the context of the argument about state immunity, the arbitration agreement only became embodied once the English courts had definitively said there is such an agreement. Until then, there wasn't. Now, and that is why I say that what the English courts' judgments did was effectively generate a contract containing an arbitration clause as between Spain and the club. Now, I fully accept, my lady, Lady Justice Andrews, that the court declared that to exist, but it was not by no means certain, and indeed, it was only upon that establishment that there was a definitive right or obligation.
So your point is that Spain was fully entitled to say, well, we're not bound by an arbitration clause, so we're bringing proceedings in Spain, and we did so first in time, actually.
Yes.
Albeit criminal proceedings and blah, blah. And was entitled at least until the Court of Appeal determined that it was not, to say that it was not bound by the contract. Now, the problem with that is, how can it do that when it is seeking to take advantage of the terms of the contract and to accept certain parts of it and reject others, even before the Court of Appeal reaches that conclusion?
The answer is, it doesn't say it's not bound by an arbitration clause. It is the equivalent, in the example that I gave to Lady Justice Falk, of parties with a contract containing an undoubted arbitration clause deciding whether or not to arbitrate. Spain was saying, fine, okay, we've now had a determination that there is a binding arbitration agreement between us, but we can still proceed in court in spite of the arbitration agreement, and you have the right to rely upon the arbitration agreement to the extent that is otherwise available. So it's the extraordinary situation in this case generates precisely that. As I say, in answer to Lady Justice Falk, it's not an actionable breach to commence English proceedings where in an English domestic contract with an English arbitration clause, because the right of the defendant in such proceedings is to seek a stay. It's the nature of the right which is generated by...
I'm sorry, that's just completely wrong.
Ooh.
Of course it's a breach. The contract says
I said
you shall
actionable
do
breach.
this. But yes, it's an actionable breach. The claim for a stay is an action commenced based upon the breach.
Then in which case, my lady, what I said, I would fully accept that what I said was wrong. On that basis, I fully accept. But the remedy is the right of us to seek a stay, and if that stay is not sought, then continuing with the English proceedings in the example that I gave to Lady Justice Falk, doesn't generate any cause of action in compensatory cause of action. That's the point I'm making, my lady. Otherwise, in every case where a stay is unsuccessfully sought, because there's a step in the proceedings or whatever, and the English court can go through to final judgment, there is then an almost automatic right of damages to defeat that English judgment.
Presumably, somewhere in these thousands of authorities that we've got, I have surrounding me, you'll find an authority that supports that proposition, Mr. Young.
Well, there is no authority supporting the proposition that there is then a cause of action in damages when you get through to the end. But I say that the reason there is no authority is precisely because the remedy is that of seeking a stay, and it doesn't give rise to compensatory actionable claims if the stay is not sought. So to that extent, the absence of authority is something upon which I rely, because there would be a host of cases otherwise where defendant has failed successfully to seek a stay and then been condemned in a judgment of the English court. He would then say, well, yes, but that condemnation is a result of your breach, O claimant, and I recover damages equal to the costs and damages awarded by the English court. So the absence of authority is something upon which I rely. Your ladyship looks puzzled. I'm anxious to...
I'm not going to debate it with you.
No.
You've made your submission.
My lady,
I understand it.
there is no authority for the proposition that a failure to make a stay application by a party to an undoubted arbitration agreement has a right of action in damages if he loses court proceedings. I'd say that. Otherwise,
which he has not participated.
In which he has or has not participated.
If he has participated in them, he's waived his rights to go to arbitration. If he seeks a stay, there will be no court case.
Correct. If he seeks a stay unsuccessfully.
We're dealing with a very unusual situation in which the party who is the wronged party in this situation says, I'm not going to waste my time going to court for a stay. I'm going to let you do whatever you like with the court proceedings. I'm going to rely on my right to arbitration, and I'll seek damages against you for breach of the arbitration clause. Now, buried away in the mists of time, I seem to remember that there might be some authority that suggests that you can get damages for that breach, but I may be wrong.
Under those circumstances, I can't think of any. But, I mean, my lady, one has to remember, in this case, the Supreme Court was a case where the Supreme Court judgment in Spain was one where the club did not participate. But it did participate in the assessment of damages when it was remitted to the provincial court. So the club did participate. My lady, I'm anxious not to be seen to be debating the point with you, not least because at the moment I'm still just identifying the issues. But I hope it's at least of some use in helping the court understand the position. The second sub-point of point 8, which we departed from some time ago, is that equitable compensation is not available in the present case because Section 50 is premised upon it not being available. And indeed, as Lord David Richards put it in Oudon, that equitable compensation is available for breach of a fiduciary duty, extending the breach of confidence. But here, there is absolutely no fiduciary duty alleged. So equitable compensation is a very narrow creature, both historically narrow and as a matter of the very premise of this Senior Courts Act, Section 50. And it doesn't extend, it doesn't extend more generally the powers of the to award equitable compensation, which would otherwise render Section 50 completely vacuous, pointless, misconceived.
It is possible, isn't it, that the pay to be paid clause and not giving effect to that is in a different category from the arbitration clause and not giving effect to that.
Absolutely.
And it would be more substantive, the pay to be paid. So when you come to seek equitable compensation, if you're just seeking equitable compensation for the failure to arbitrate, I at least see your argument on that based on your example. But what about getting a Spanish judgment which overrides the pay to be paid clause and in breach of your now clear contractual obligation to be bound by the contract?
Yes,
Quasi-contractual obligation to be bound by the contract.
To be bound by the arbitration clause. That's all that Mr Schaff decided.
Well, I think that Mr Justice Hamblin and Lord Justice Moore-Bick, was it, were characterising the obligations as contractual.
That was yes and no. The reason why Mr Justice Hamblin characterised it was in order to characterise the nature of the claim for criminal injury compensation brought in Spain, as to whether it had the contractual, were a contractual foundation or a non.
He said it was a contractual foundation and therefore you were bound by the arbitration clause.
Correct. But what Mr Schaff's award and in due course the Section 66 judgment did was just to say the club has a defence of pay to be paid. Fair?
Said both things.
Sorry?
Said both things. Obligated to arbitrate and pay to be paid.
Yes. Yes. One creates an obligation. The other, the arbitration clause creates an obligation. The other creates a right in the club to rely upon a pay to be paid clause. The pay to be paid clause imposes no obligation on the claimant.
Well, I mean, I'm not sure that is the right characterisation of a pay to be paid clause. I think the pay to be paid clause is simply a term of the insurer's obligation to indemnify.
I agree.
And the insurer has no obligation to indemnify until a claim is made and it is stated in the claim, putative claim form, we paid the victim $1 billion on the 14th of January, please indemnify me against that payment.
Yes, but then you have to ask yourself, the rights of direct action against insurers, which rights of direct action exist in many legal systems.
Yes, including our own.
Yes, now, yes. The rights of direct action may or may not be stymied by a pay to be paid clause. That would then, it would depend entirely upon how that defence could have been formulated by the would-be defendant in the form of the insurer.
in the appropriately.
But just to try and elucidate your submission and to understand it fully, you say what gives you the right to enforce this judgment without a collateral obligation to pay equitable compensation is really two things. That you brought your claim in Spain first. At that time, you were not bound by any arbitration clause anyway, by any clear declaration of that liability to be bound by it. You were fully entitled to take advantage of Article 117 of the Spanish Penal Code or whatever it is. And you did. They chose not to defend on the basis that they had no liability because of pay to be paid.
Correct.
All that took place. Only later were the Schaff arbitration proceedings begun, and it was declared and then eventually endorsed by the Court of Appeal that
Right.
you had to arbitrate. But by then, the arbitration didn't. The fact that you hadn't arbitrated didn't matter because there'd already been liability determined in Spain.
No, the
That's
determination of
not quite
liability came after, a couple of months after.
But the proceedings were already in train.
Correct.
And they took precedence under the Regulation C Court of Justice, and there's no equitable compensation because they didn't defend on the basis at all on the basis of the arbitration clause. They didn't defend on the basis of the pay to be paid, and they therefore lost or waived, in my lady's terms, the right to do so.
Yeah,
And you're not taking advantage of something that is unfair and unjust because it's a direct action under Article 114.
exactly.
Okay, well, I think I've got it.
My Lord, I'd hesitate to rise, but your Lordships do need to understand what is before this court and what is not.
Well, that's why I asked where it was to be found in his skeleton.
Absolutely, my Lord. I do have that point. The point I seek to rise to make is that in the arbitrations themselves, and this goes back to my Lady Justice Falk's point, two matters were raised.
Which arbitrations?
In both the Spanish and the French arbitrations. That's
No,
to
you
say,
mean Sir Peter Gross.
Sir Peter Gross and
Dame
Dame Elizabeth Gloucester.
Yes.
And what was said is that you caused your own loss by failing to make an application for a stay in Spain, which would have succeeded if you'd made that application. That argument was refused by both arbitrators. And then the second argument was you could have gone armed with your judgment or your award to Spain. That argument was refused as well, on the basis that as a matter of Spanish public policy, the Spanish court would not have recognised an English award or English judgment rendered at the time that these awards and judgments were rendered. So in the arbitrations, those points were taken and refused.
The arbitrations are under appeal.
Not on those points, my Lord.
Right.
And equally, one last point is the argument that there shouldn't be, if you like, the court shouldn't, with one breath, give by giving a judgment, and with the other breath, take away by awarding compensation for the giving of that judgment. That was a point which was run by France, but not by Spain, in the appeal before Mr Justice Butcher. France were out of time for filing their appeal. They had 4 grounds, and that ground was the 3rd and 4th.
And those are not appealed either.
And Mr Justice Butcher refused them the extension of time for that point and refused permission to appeal to this court on that point. I hope, my Lord, that's helpful.
What my learned friend has said is right up to a point. It is true that the point was run unsuccessfully, that by the time the case came before the the Supreme Court in Spain, late 2015, early 2016, the evidence was, and it was accepted by the arbitrator, that an effective application to stay the proceedings could not then be made. That's true. But, and this goes back to a point I think that my Lord made, or possibly Lady Justice Andrews made, that the right to a stay existed back in 2010 when the Spanish proceedings were initiated. The club did not need to have an English award or an English judgment to reinforce that right. So it is true that the right had been lost as a matter of Spanish domestic procedural law, but it was available, necessarily available to the club back in 2010, 2011, when it could have been. So it's almost about the as it were, the procedural rules of Spain as to when an application to stay can be made. That was the critical point.
I think you're going to have to come to that in its proper place.
Yes. Yes, I think I've got to the end of my 8 points originally.
Yes.
Before I move on, can I just say how the division of labour is to be effected? I'm going to argue the regulation appeal. Ms. Patel will be arguing the human rights appeal.
The human rights appeal is the third one.
That's the third, yes. Ms. Dilnot will be arguing about 98, well, I think the bits that we haven't touched on yet in the equitable compensation, equitable damages point in the arbitration appeal. I think I've made some.
Well, that's the only point in that case,
yes,
except
it
the
is.
injunction.
Yes, that's right. And I'm not quite sure when Miss Norris is going to represent the European Commission.
Well, let's ask Miss Norris when she would presumably normally come. Probably after you.
Yes, there was some question as to whether she wanted to hear what Mr. Delamere, who's Mr. Delamere.
Would it be helpful if I handed up a copy of the agreed timetable?
That would be brilliant. Can it be sent electronically?
I'm sure it can, but just for the moment, then I hope paper will do.
Paper never does for me, as you know.
I'm afraid I'm in the school of Lady Justice Andrews. I love paper. I know there are two very distinct views.
Yeah. Okay. So you do. Miss Norris is going to come after you, as thought.
What we've agreed, my lord, is Miss Norris is going to take 45 minutes of her hour, and then she's going to have 15 minutes to reply to whatever I have to say on the EU law.
You can be guardian of that document.
Right,
It'll be sent electronically, I'm sure, by your juniors.
Okay. Yes.
My Lord, if I may, on behalf of the Commission, we are here very much to assist the court. However, our role is one in which we are not supporting one party or the other, and that is the reason why we agreed with counsel to split our observations such that we would address any points on which further assistance may be useful following the replies. And if the court is minded to agree to that running order, then we are at the
Well, I'm sure if the running orders agreed between the parties, unless we find it inconvenient at some later stage, we're very happy that you've agreed.
Looks pretty sensible to me.
Right.
Good. So
think
you've got your distribution of labour, but I would like to know the points you're going to address, and I would also quite like to know, just as a foretaste, whether this point about submission, forfeiting the right to argue.
I must be frank. I don't think it has it in so many terms. It appeared in the skeleton argument, but I will, if your lordship.
Well, don't deal with it now then, but get maybe Miss Patel to have a look at it over the short adjournment and see if you can find any.
Yes, indeed.
Even vague or colourable reference.
Yes.
To it.
Now, my lord, I have 7 submissions on the regulation appeal, and I think there are no sub points. The first is that Mr. Justice Butcher and this court is bound by the judgment of the CJEU, and that judgment is binding and determinative of the issues under both Articles 34.1 and 34.3 as a matter of UK law. 2.
Or maybe English and Welsh law would be more relevant here.
Yes, I don't think Scots law necessarily features particularly strongly. I'm quite often in my note I've thought I'd put English law, and I thought no, it must be UK. But your lordship is right. The second is there is no express or implied exception on the binding character of the entirety of the Court of Justice judgment. 3, the English court, like any member state court, has no jurisdiction to review the vires of a Court of Justice judgment with a view to avoiding being bound by it. 4, the Court of Justice did not exceed its jurisdiction materially or at all in answering the questions which were referred to it as it did. 5, the English Section 66 judgment is not a judgment for the purposes of Article 34.3 of the Brussels Regulation. 6, there is no available rule of public policy.
Sorry, you're going a bit too
Sorry,
English Section 66 is not a judgment
for the purposes of Article 34.3.
Yeah.
6, there is no available rule of public policy strictly construed and applied under EU law as it must be for the purposes of Article 34.1. Still less one which is manifestly offended to an unacceptable degree, so as to engage the exception of the exception to enforcement of Article 34.1. And 7, Article 34.3 is not engaged as a doctrine of res judicata, issue of estoppel. It cannot be engaged under 34.1 either in relation to the judgment or the award of Mr. Schaff, embodied in the Section 66 judgment. It's 34.3 is the only way that issue estoppel by way in the present form can operate. So, my lord, I start with the regulation appeal. I'm sure the court will have looked at the regulation. It is in Authorities Bundle 1, at tab 14, page 283 and following. And I just wonder if I can very quickly skip over, by way of introducing the critical parts, risk of
the bookmarks on the electronic version of the Authorities bundle for the Brussels appeal are hopeless.
As your lordship can see, coming from the 19th century version of
yes, I know, but if you want this member of the court to actually read anything, it has to be provided electronically, and
yes,
I have to know which page to go to. I do not use any form of paper, Mr. Young, and I have not for 5 years.
That's why my note has been filled with electronic references.
Good. But they're wrong. They're mostly, all the references are wrong by 7 pages. And there is no bookmark on the Authorities bundle. so that you can't readily find the documents, because all you've got is sections A to K, which give you the EU authorities, French authorities, or whatever it is. So you have to search manually for every authority you're looking for.
My lord, I too work electronically, and mine work perfectly.
Does it?
I think there must be some problem in the version that my lord has been given.
I've obviously been given the wrong version.
I've got, as you can see,
The other bundles are okay.
I'm sure we can look into this over lunch.
Yes,
and
if
provide
I could get another one. I don't mind. I'm perfectly happy to have
Your lordship catches me, as you can see. It's not my area of particular expertise.
Yeah. Okay. Anyway, let's try and just bear with me if I.
Page 283 of.
What are you looking for?
The regulation.
Which bit of it?
Firstly, it's I think I can leave the recitals for the moment. Yeah. At 285, we have the exception to arbitration in Article 2D. And then we have the general provisions and the special provisions relating to insurance in Section 3, which is at page 287. Now, I'm not sure whether I add or subtract 7.
Sorry, no, don't try and add and subtract. Just use the paper reference. That
Yes.
I can find.
287, we have Section 3, which is the jurisdiction in relation to matters of insurance.
Yeah.
What we have is jurisdiction allocation provisions that Article 9, an insurer may be sued in the courts of any member state where he is domiciled, in the courts of another member state in the case of actions brought by a policyholder, in the courts where the plaintiff is domiciled. And then Article 10, respect of liability insurance or insurance of immovable property, the insurer may in addition be sued in the courts of the place where the harmful event occurred. And if it's relevantly construed, the P&I insurance is relevantly construed as liability insurance, then the relevant damage, harmful event was in Spain. And then Article 11.2 says Articles 8, 9 and 10 shall apply to actions brought by the injured party directly against the insurer where such direct actions are permitted. That permits direct action. And then Article 12, without prejudice to 11.3, which I don't think matters, an insurer may bring proceedings only in the courts of the member state in which the defendant, that's the defendant to proceedings brought by the insurer, is domiciled, irrespective of whether he is the policyholder, the insured, or a beneficiary. And the way that jurisprudence developed is that makes Spain effectively a relevant defendant. So the insurer may begin proceedings only in Spain. There is then a question, and that arises in context of the Court of Justice judgment. And then whizzing through Article 34 is at page 292. I think the court will have seen Articles 34, 3 and 4. Article 34.6, this is one that I mentioned, sorry, not 34, Article 36. Under no circumstances may a foreign judgment be reviewed as to its substance. So this raises the point that was, I think, adverted to by my Lady Justice Andrews, is what happens if the judgment, the incoming judgment, is so fallacious in considering the pay-to-be-paid case, for example. The answer is Article 36 says you can't look at it. And then Article 45 at page 293. And this is quite an important one. The court with which an appeal is lodged under Article 43 or 44 shall refuse or revoke a declaration of enforceability only on one of the grounds specified in Article 34 and 35. And that's why Article 34 acquire their exhaustive character. And while we are here, the Gennard report, the court will doubtless remember back in the halcyon days of the Civil Jurisdiction and Judgments Act, how the report of Professor Gennard featured. That's at page 310. I suppose en passant 309 referring to Article 10, but page 310, looking at what was then Article 27 of the Brussels Convention, subsequently became Article 34 of the regulation. Under the heading of public policy, recognition may be refused if it is contrary to public policy in the state in which recognition is sought. In the opinion of the committee, this clause ought to operate only in exceptional cases. As has already been shown in the commentary to Article 4, public policy is not to be invoked as a ground for refusing to recognise a judgment given by a court of a contracting state, which has based its jurisdiction over a defendant domiciled outside the community. I don't think that matters very much. Then on the facing, the last paragraph on the left-hand column, the wording of the public policy provision is similar to that adopted in most recent conventions, in that it is made clear that there are grounds for refusal, not of the foreign judgment itself, but if recognition of it is contrary to public policy in the state in which the recognition is sought. It is no part of the duty of the court seized of the matter to give an opinion as to whether the court judgment is or is not compatible with the public policy of its country. And then over the page 311, we have the consideration of incompatibility. Perhaps the third paragraph in that, on the left-hand side, under that heading. In the opinion of the committee, to treat this as a matter of public policy would involve the danger that the concept of public policy would be interpreted too widely. And then on the facing column, second paragraph, the committee preferred a form of wording which does not decide whether the judgment should have become res judicata or should merely be final and conclusive, and left this question to the discretion of the courts in which recognition is sought. So Gennard, looking at Article 27 in the original convention, said it's wrong in principle to take irreconcilable judgments as public policy. That is to give public policy too wide an ambit. Now, there are, so that's the regulation as construed. Now, there are two central propositions as a matter of English law, UK law. One is that the EU Withdrawal Act, as amended, expressly provides that any Court of Justice judgment in a case referred before the end of the transition period, as this one was, binding its entirety on and in the United Kingdom. Now we've got the, we can look at the Act, but possibly the most convenient place to see it is in HMRC v Perfect, which is page in the authorities bundle, my Lady Justice Andrews authorities bundle 3, tab 31, and it's page 698. Now, this is, I think, just the most convenient way of assembling the statutory provisions.
Sorry, do you have a tab number for that?
I have a tab number is 31.
Okay.
I'm more in hope than confidence. I think that's right. It's right in the paper version. That was I don't think we need to get too much involved in the case. It was a lorry driver who was inadvertently caught importing unlawful material, or importing alcohol. He was unaware of it, and there was a reference to the the CJEU as to whether that exposed him to liability for various revenue provisions. I don't think we need to look at them. And it's at page 705 where the learned Lord Justice Newey, sets out the provisions of the withdrawal agreement, the withdrawal act, and I'm not sure that it's profitable for me to take you through those details now, unless you would like to. But the court concluded that they were bound at paragraph 22 at page 707. We're bound by the CJU's judgment to hold, as was anyway this court's inclination, that Article 33 of the 2008 directive, and hence also Regulation 13 of 2010 regulations, and they held that they were bound. They would have done anyway, but one of the characteristics, one may think, of a binding judgment is not when a judgment is made that you think is right, but its binding quality only really manifests itself when you think it's wrong, but you're bound to apply it. But his lordship there set out the how it is that the provisions of the withdrawal agreement became embodied in the section 7A of the 2018 Act, and how it became binding. And we can see that it's binding in its entirety. So I'm really showing you, I think, where perfect is. The odd thing is about perfect, in many ways, that the learned judge didn't once refer to it. He didn't refer to the fact that the Court of Appeal had held that Article 89 created a binding obligation. So it's not just as a matter of English statute and UK international agreement, it's also Court of Appeal authority.
Well, he spent an awful lot of time explaining why it wasn't binding, so perhaps he was assuming that it was binding unless he could find some reason for saying.
I think there are two things one could say about it. One is that another assumption that he made is that if it is binding, it forces him to a conclusion completely different to that which he wished to come to. So, and in that respect, he is absolutely right. It did. But it was a case where he clearly didn't like the fact that it was binding, and he was going to use his massive intellectual powers to find a way round it. Unfortunately, he used a mechanism akin to, or analogous to, a JR, reviewing the vires of a subordinate tribunal or subordinate legislative body. Whereas there is no such power, no such JR-like power in any member state court. And the very fact that he had to engage in such intellectual contortions, and I do suggest that's what they were, rather indicates that he knew jolly well that it was binding in its entirety, and it produced the result which he did not wish to engage in. There are in the Withdrawal Act no qualifications or provisos. It is the only statement in the Act is that CJEU judgments falling within the present are binding in their entirety. Now, in order to conclude that they are not binding, one has then to, there is no express proviso in the Act or in the agreement, so one has to imply one. And how, in heaven's name, one implies qualification? Unless, and this is the only way that it can be put, I think, Article 86 refers to continuance. And
refers to what? Continuance.
Continuance. I should perhaps just show you perhaps the Withdrawal Act itself. It's the authorities bundle.
You mean the withdrawal agreement?
Bundle.
Yes.
I'm sorry?
You mean the
withdrawal agreement?
I mean, we've got it in perfect at page.
Yes, indeed.
At page 705 in
yes.
the paper.
Yes.
And it's Article 86, which is headed pending cases before the Court of Justice.
Yes.
And provides in 86(2) that the Court of Justice shall continue.
Exactly.
To have jurisdiction to give preliminary rulings on requests from courts and tribunals of the United Kingdom made before the end of the transition period. And Article 89 says judgments and orders handed down before the end of the transition period, as well as those handed down after, shall have binding force in their entirety on and in the United Kingdom.
Yes, and the point that I was perhaps alluding to was that the only way that one can see any conceivable loophole is in the word continue, and that somehow before Brexit there was a right in the English court or all member state courts to engage in a judicial review of vires of the Court of Justice. And there is, as the court will see in due course, that not only is there no authority for that proposition, there is now quite a body of authority against that proposition.
Well, you've got to deal with what the judge said, haven't you?
I will do that, my lord. I'm going to come on to it, but what he said was, his basic argument was, there are some ECJ and CJEU judgments which limit their jurisdiction in some ways. Now, he says, therefore, when they limit their jurisdiction, it is possible for any member state court to do likewise and to say that the CJEU has acted in excess of its jurisdiction. And he sets out 7 principles, although in fact I think possibly there may be 8, which actually don't support the proposition that there is a JR-like vires review jurisdiction in each member state court. And the reason being, and I'll come to this, that the whole premise of the Court of Justice is to ensure the uniformity of interpretation and application of union law. It does that in a number of ways. Article 267 of the TFEU, Treaty for the Functioning of the European Union. It does it by answering questions, broadly speaking in the abstract, which state the law, which is then binding on a referring court and binding on all member state courts. And member state courts can't then choose which ones they wish to be bound by and which ones they don't. They are bound, full stop. Member state courts have no jurisdiction to review vires. There have been a couple of occasions when some member state courts have tried it. The German Constitutional Court tried it in a case called Weiss, and they were roundly rebuked. The Commission began infringement proceedings, and Germany backed down. The French Cour de Cassation tried it in a case called de Groot and withdrew. And I'll show you what there's a very recent case. It's post the end of the implementation period. But there's a recent case where the Court of Justice have made it abundantly clear that member state courts do not have a power of review of the CJEU judgments. That is a judgment to which you've got to pay due regard. You're not bound by, but it's due regard, but it's consistent with what goes before. And if member state courts cannot review vires and thus decide what they wish to be bound by, then everything that the learned judge said with regard to the vires of the CJEU is simply beyond his power. And yes, he goes on at very considerable length dealing with it, but it's all on a false and unlawful premise.
Well, you presumably submitted that, did you?
I did. I did. And he did not want to, he did not wish to limit his own powers of review. And he was wrong. I mean, I don't, there's no getting away from the fact.
Right, we don't need 7 days then.
Well, I don't think,
marvellous news.
Well, absolutely. I don't think we do, strangely. It's only dealing with the intellectual quadrille that the learned judge is gauged in that forces me to spend more time on a point that's utterly academic. But there is no jurisdiction in member state courts and none in the English court. There was one paragraph where he said, even if there's no jurisdiction in other member state courts, there is a jurisdiction in the English court under the Withdrawal Act. But he didn't explain how that arose. It has to be said that his determination not to be bound was manifest, very manifest. And of course, if he didn't have the power to do it, it can be his desire was just unlawful and wrong, as I submit it was. But he was right to think that if the judgment was binding, then that was dispositive of the case before him. There is.
Well, he did apply the answer to question 3.
He did apply the answer to question 3, and then
only rejected paragraphs 56 to 72. Or whatever.
Yes. It was the way that it was developed by my learned friend, Mr. Hancock, with characteristic skill, was that the judgment of the CJEU, which we will have to come to, was in 2 distinct parts.
Well, 3 parts.
Yes, well, yes, 3. But so far as the irreconcilable judgment is concerned, in 2 parts, and only the first part is binding. But when you look at
what he said against you, I mean, I know you make the, if I may say so, bald submission that it was binding, and therefore binding.
Yeah, that is what I say.
Which I do understand my own part. But what he said against you is that he deliberately did not refer the question that the court answered in those paragraphs, and he had referred 2 questions that raised what they call the solo point and the scope point.
Yes.
And that was all he asked, and they weren't entitled to answer things he hadn't asked because he had deliberately rejected the application that there should be a reference in that respect.
Going to show you that, first of all, actually, the answer that the CJU gave was completely in line with the solo. I'll show you, I'll come to this.
I mean, for my part, I find the solo argument, just at the moment anyway, completely irrelevant, because it may well be that he asked a question based on solo or not, but the question is the question, and the question we have to answer is, was the judge right to say that if I ask question X and they answer question X plus 1 or Y, it's not binding. And I know that you say that's rubbish as well.
Well,
You say that's still binding because they do this all day long. And
and to be frank, with the greatest of respect, so does your lordship's court. If the question
I could take offence. I could take offence.
My lord, I don't think you will.
Of course we do. Yeah.
Yes. I mean, is there a binary answer, yes or no, to question A? Is it a judgment or is it not? Well, the answer is it's capable of it, but there are qualifications. When we give the answer, we've got to give the answer that is correct in law, and it's not an unqualified answer, it's a nuanced answer. So it's not they answered question X plus 1, they answered question X in the correct and nuanced qualified
that's
way.
what you say. That's
what
not
I say.
quite what Mr Hancock says.
No, well, he wouldn't, would he?
No, he wouldn't, but he doesn't. I mean, and you have to deal with what
Well,
he
and I
does
will
say.
show you, I'll show you that, this is, once again, I'm leaping on a little. The instrument which came before the Court of Justice, and which was then sent out to all of the observing parties, was the reference itself, not the reference judgment, or the judgment by which the learned judge justified the reference.
Right.
And you won't find any refusal in the reference. Actually, when you look at the reference judgment that he delivered, the only refusal that he engaged in was a refusal to refer the human rights point. You do actually have to hunt very high and low through his reference judgment to see any basis for him saying that he hadn't referred other.
But I mean, I think your point is a more fundamental one, which is it doesn't matter.
Yes, it absolutely is binding. Is binding. Is binding. Is binding. Yes, absolutely.
So
and in its entirety.
So you don't get to this point.
You don't get that. No. It's binding and entirety are
So, even if they've undoubtedly answered a totally different question, you would say that's binding.
I would say that's binding, not least because, and I'll try to show you, it's up to the CJEU what questions it wishes to answer. And once they answer the question, then it's within their jurisdiction.
Is it more that they are the sole arbiters of their jurisdiction?
Yes.
Is that the,
that's absolutely
that's
right.
the critical point?
Yes. And
that it's not part of the role that you say of the member state court.
no, it's my lady. You've put it exactly as I wished I'd put it. Absolutely right. And indeed, it's a point I made earlier. But as soon as individual member state courts take it upon themselves to review what is and what is not binding, then it is a recipe for differences.
Well, you say that way lies chaos.
Yes.
Because you can't have a top court that is subject to different kinds of review in different courts around the EU. I mean, let's assume for a moment that all that is right. There still has to be coherence to what it says. So that it has to be clear what it is saying and what it's not saying. And the thing that is probably most controversial is that is the Hamblin judgment. I mean, I call it that, but we
I know what you mean.
include the Court of Appeal, because what is said is that was not referred by Hamblin. It became a final judgment. It could have been referred, or by the Court of Appeal, or by the Supreme Court. It became a final judgment, and therefore it wasn't open even to the top court to say that is not binding anymore in subsequent proceedings, because that way lies chaos too, because you have certainty of outcome, which we all value very highly, and so does the European Union.
Yes, I mean, there are tied up in the proposition that your lordship has just put to me a number of rather different features. I think one has to start by saying that as I said earlier, the issue decided by Mr. Justice Hamblin was, should I enter the Section 66 judgment? I can, because although there are provisions in the regulation, they are completely irrelevant to the question of whether I should enter the judgment, because this falls within, my judgment falls within the arbitration exception. That's what he decided. The Court of Justice then, later, became engaged with the question of whether that judgment was a judgment that was irreconcilable under the terms of Article 34.3. Not should judgment be entered, but having been entered, what is the effect of that judgment?
But I think my Lord's comment is that there's a paragraph in the CJEU judgment that specifically addresses effectively whether Mr. Justice
I agree. Paragraph 72, it's imprinted upon my mind. Sorry? 71? Oh, God, such is the imprint. Such is the imprint.
But paragraph 71 actually refers to Mr. Justice Hamblin and the Court of Appeal and says they shouldn't have done what they did. Mm. So that rather goes against what you've just said, which is that they did something completely different. Nothing to do with what the Court of Appeal.
No, what I'm going to say, we've got to look at what they did. But that paragraph is not determinative of the abstract statement of law, dispositive abstract statement of law, albeit, given by the Court of Justice. We will have to analyse it at some point.
You told me it was easy.
It is.
Oh, good.
It is easy. And when you actually consider what the judgment, what the conclusion of the judgment was, it's actually entirely rational. And to take a word used by my Lord, coherent. It is a completely coherent and that one paragraph was, as it were, an obiter dictum saying, in practical terms, this shouldn't have happened, but it doesn't alter the substance of the CJEU's thinking.
Well, I think you're effectively saying we should ignore that paragraph.
I'm saying you should look at the judgment in its entirety, but it doesn't alter. It doesn't alter the conclusion of law, EU law, to which the Court of Justice came.
But it is problematic. It is
yeah.
inconsistent.
It was something that was complete. It was one of those unnecessary obiter dictum, perhaps. Whether an obiter dictum is binding, I don't know. But it's, yes.
Well, I mean, if the judgment is binding, it's binding.
It's binding, it's binding, it's binding, yeah.
And so it may not be relevant to what we or somebody else has to decide, but that doesn't mean it's not binding.
Correct.
Your submission, right?
Yeah, that's it. As you say, my lord, it's binding, it's binding, it's binding.
Yes, I'm sorry I said that.
No, I'm not.
But if we look at paragraph 71, which I am, I mean, it is talking about, it says, it is for the court seized with a view to entering a judgment in the terms of an arbitral award. So we're now looking to Hamblin's decision-making to verify that the provisions and fundamental objectives of the regulation have been complied with, to prevent a circumvention of those provisions, such as a circumvention consisting in the completion of arbitrating proceedings in disregard of the relative effect of an arbitration clause included in an insurance contract and on the rules on lis pendens. So in other words, Hamblin should have, as a matter of law, had regard to the regulation when he was considering entering a judgment under Section 66.
Yes.
Correct? That's what it says.
That's what it says.
He should have had regard to that. it's apparent from the documents before the court that no such verification took place by Hamblin or by the Court of Appeal. So I'm immediately, my hackles rise to that. And neither of these two courts made a reference to the court for a preliminary ruling. So it is really criticising something that happened in the past, but what do you say about it? You say it has no further effect than that.
Yes. When you look at the entirely rational and coherent conclusion to which they came, which I will address you on, looking at the past was irrelevant to that analysis. What they do say, however, and this is setting down, as it were, prospective EU law, is it is for the court seized with a view to entering a judgment in terms of an arbitral award to verify the provisions, saying that going forward, courts entering the equivalent of Section 66 judgment should verify. The fact that Mr. Justice Hamblin didn't was a subject of complaint, of criticism by the court, but it doesn't alter the substance of their reasoning.
Right.
I would, in all frankness...
What did the judge say about this paragraph?
He didn't as such... sorry, my lord, you take me just momentarily. He said that this was going beyond their jurisdiction because they were touching upon something which had become an issue of stop.
So it's at 187.
187. 187, thank you.
187, he says, the inconsistency is starkly revealed by paragraph 71.
Yes.
He says what it says. In my judgment, he says, what had in fact happened is that this matter had been considered and it had been decided there was no inconsistency with the regulation. Even though that decision does not accord with what the CJEU has indicated in its judgment should have been the result, this doesn't alter the fact that the decisions were made and are res judicata. So what do you say about that?
And yes, I am perfectly content that it is res judicata for what it actually decided, which was that Section 66 judgment was appropriate to be entered. The fact that the Court of Justice took a different view is not material to the present appeal in any way. Because what you have to do is apply the judgment of the court. I mean, I'm anxious to deal with the judgment of the court when I've shown your lordship a couple of other points, but perhaps I can...
Well, your submission is that he's right that Hamblin is res judicata for what it decided.
Yes.
But what it decided was simply that the judgment, the award should be reflected in a judgment.
Yes, that's all it decided. It didn't decide what effect it had under Article 34. I think we're not asking for any different Hamblin judgment. We don't need to. All that Mr. Justice Hamblin decided was that it was appropriate in the exercise of his discretion to enter the judgment and that the provisions of the regulation didn't have any impact because it was within the arbitration exception. What the Court of Justice have done is to say they don't think that that's a particularly sound application of the arbitration exception, but it does not matter. It doesn't matter to what they actually decided.
Right.
They
actually decided is what we find, I think, in 73, is it?
Yes. I mean, perhaps the court will just give me a moment so that I can put and return to a point. I can come to the judgment itself. What the court, and it was the Grand Chamber, held was that first, a national judgment enforcing an arbitration award may be an irreconcilable judgment available to meet an incoming regulation judgment if, but only if, it was a judgment which that national court could itself have given in its own right, i.e., on the hypothesis that there was no intervention of an arbitration. An arbitration, of course, falls outside the regulation because of the exception. So its conclusion is that if it was a judgment that the court could give on its own, irrespective of doing so by way of the Section 66, then it's an irreconcilable judgment. But if it was a judgment which the court could not give, absent arbitration, then it's not an irreconcilable judgment under Article 34.3. That's the absolute kernel of the point.
Well, how does that work in real life?
In real life, if an arbitration award is enforced, and the court could
so it's a pure fortuity, really, whether the arbitration is or is not, whether the Section 66 is or is not one that could be an irreconcilable judgment, depending on whether the regulation gives jurisdiction to the home court, if you call it that.
Yes.
And it's quite complicated because we know that the jurisdictional provisions, although you read them out very quickly, they're not actually always easy to apply.
No, I would agree with that.
You can see all kinds of ramifications for international arbitration, if that's right, because you could have a situation where a Spanish claimant and a French defendant decided between themselves that they were going to settle their disputes by reference to London arbitration and English law, and there was no other connection whatsoever with this jurisdiction. And the Spanish party wins. It goes off and gets the award registered under Section 66, and the French losing party doesn't like it very much. So it goes off to France and gets a conflicting judgment. It said, well, the Section 66 judgment can't be prayed in aid because the English court wouldn't have had jurisdiction over that dispute at all. And it wouldn't.
Well, strangely, I mean...
Well, it wouldn't, Mr. Young, would it? I mean...
I'm not...
I mean, is your answer to all this, it doesn't matter. It may be completely bonkers.
Yes, I say it's not completely bonkers, but yes, it doesn't matter. It's what the Court of Justice has said. Is you've got to ask yourself, in any particular case, was this a judgment which this court could have given in its own right? Now, in my Lady Justice Andrews wrinkles her brow, but...
well, she might be like Mr. Justice Butcher. She might not like the idea that the Court of Justice has said something that is bonkers by which we may be bound.
Yeah.
But that doesn't mean it's wrong. I mean, we need to know your submission. And your submission, as I understand it, I mean, I'm imagining, but you confirm it, is that you may say it's all rather difficult and silly and is going to create work for the working people to do the well of the court. But
which I include myself and yourself, my lord.
Indeed, but you may say that, but it doesn't matter to this court because you've got to apply.
Yes, absolutely. And there is no doubt but that it was dispositive, to use a word I think used by Lord Hope in the Nectar Card case. It's dispositive of the present dispute.
And you say, I suppose, the judge was wrong to think that it wasn't an answer to the question he'd asked, because actually it was. It was saying, well, the answer to the question you've asked is that a judgment can only be a judgment, an irreconcilable judgment, within Article 34.3 if this condition is satisfied.
Yeah, absolutely. That's yes. It is. It's the question. It's the answer to the question, which, and as you'll see, the Court of Justice, one of the principles that they engage in is to endeavour to give assistance to the referring court, and not to give a misleading message to the referring court. So yeah, they answered. They gave an answer. They gave the definitive answer, and to the question definitively posed. But yes, and I would suggest it is not barking. I'm just slightly troubled by the example that my Lady Justice Andrews gave.
Well, it is a troubling example, Mr.
Yes,
Young, as my lord says, it doesn't matter if the decision has widespread undesirable ramifications. It's either binding on us or it's not.
Yes, well, that's absolutely right. But
it does have widespread ramifications, and they are potentially very undesirable.
Well, yeah, not necessarily undesirable. I think the example, if I may just just briefly dwell upon the point raised by my lady. There is every reason to suppose in the example you gave that there would have been a submission to the jurisdiction of the English court as the seat of the arbitration, and that would make the English court very arguably an appropriate court that could give judgment, because both parties had I mean, perhaps it's just
I'm not sure which article that would fall under, Mr. Young.
It would fall under the choice of jurisdiction clause. I mean, if I may respectfully say so, my lady, the example that you've given is somewhat unrealistic. It
happens all the time.
Well,
London arbitrations, as you know, Mr. Young, many arbitrations in the LCIA and elsewhere, ICC, involve totally foreign parties who decide to submit their disputes to English arbitration, which may have nothing whatsoever otherwise to do with this jurisdiction.
Oh yes, but that's there's the decision in, I think it's C&D, which one of the many C&Ds, which says what the jurisdiction of the English court is under those circumstances. So I fully accept, my lady, that one can, I'm sure, configure examples where the judgment of the CJEU might become unworkable. I can well see that. But what the judgment of the CJEU did was to provide a foundation for deciding what judgments were and what judgments were not within Article 34.3. And that comes back to the point made by the learned master of the rolls, that it may be that they've created a rod for their own back, but it's a binding rod.
but they have said the court has to have the jurisdiction in its own right if it wishes to make such and the purpose is that what the Court of Justice had to do was to marry together and to discern the dividing line between the arbitration exception and enforcement of judgments under the regulation. And they have drawn that dividing line where they have.
Well,
and they are the
coherent?
sole. I'm sorry, my lord. Yes.
You say it's coherent. It's a coherent marriage. I mean, if so, why? I mean, it may not matter. I do completely understand your basic submission that it really doesn't matter. But for our, intellectual.
I understand that. I mean, my first proposition would be, I'm not here to say that it was right, but I do actually say that it's coherent and it's rational in the context of the regulation as a whole. And that's one of the guiding lights of the construction that was brought to bear by the CJEU, was that it was looking at the objectives and purposes of the regulation in the construction of Article 34.
Yes, I mean, the reasoning is all about the coherence of the regulation as a whole.
Yes.
As we see, I can't remember the paragraph numbers now, but so, I mean, you do say, do you, that it is coherent, but what I find difficult is that it's a rather uncomfortable marriage of the complete exemption of the arbitration of arbitration from the regulation, but then allowing some judgments that originate in arbitration to fall within an exception in Article 34 and thereby become either irreconcilable or contrary to public policy, and others not. And what I think English lawyers balk at really is that we all thought arbitration was outside the regulation because it says so, but of course we know that most insurance contracts contain an arbitration clause, and yet there
exclusive jurisdiction clauses.
There are comprehensive provisions as to what happens to insurance litigation
and what we have,
regulation.
What we have is the dividing line. What is within the arbitration exception, what is within the regulation, and what the CJEU have done is simply define where that dividing line operates. I always, they've said the arbitration exception is all very well, but it doesn't impinge upon the securing of the objectives of the regulation. And if and to the extent that the regulation may impinge upon the arbitration exception, then the arbitration exception is not as wide as it might otherwise be conceived as being. But that's the conclusion that they have come to, looking at the objectives of the regulation, the objectives and purposes of the regulation.
But it creates a rather sort of difficult race. I mean, because the conclusion of all this is that your submission says, well, we win the race, we've got a judgment in Spain, and we can enforce it here, notwithstanding that arbitration is excluded from the regulation. We've managed to use the regulation to get our judgment enforced here, in the face of an arbitration award saying you mustn't, you can't, and you shouldn't. And so it's very much, I mean, it's a tremendous conflict created by this.
Well, I would say whenever I talk to students about study of law, I always say every case is simply about defining
where the dividing line is between A wins and A loses. Sometimes it's a straight line, sometimes it's the most oxbow-like line.
Yes, but you have to always ask whether it's right. Anyway, as a judge, and maybe not as a barrister, but as
No,
a judge,
I'm always asking myself that question.
you know, and what I'm asking myself in this case is it right that Spain should be able to enforce the judgment for $1 billion when, had it arbitrated, the pay-to-be-paid clause would have prevented it getting the $1 billion? I mean, I put that as bluntly as that.
Put it bluntly, it might have done. There is no necessary reason to decline the loyal effect of Article 34 in achieving that. It may be that Article 34, being exhaustive of the rights of refusal of enforcement, as interpreted by the CJEU, has created the conundrum that your lordship has.
Well, and then you get into all this, I mean, assuming you can even get into it, you get into asking questions like, what is a manifest breach of public policy?
Yes, and it's and manifest breach of public policy as construed within EU terms, not English terms, and to an unacceptable degree. I don't know what that is. Fortunately that's for your lordship. But it's got to be to an unacceptable degree.
I mean, the problem is that it may depend on, which is what I mentioned this morning, it may depend on what the view one takes about the sanctity of arbitration.
Yeah.
Because you might say, well, it is manifestly a breach of English public policy that you ride roughshod over an arbitration clause of this kind and would throw international trade into chaos.
Well, except that yes, it wouldn't. If, for example, the Prestige were operated by Maersk, one of the big shipping lines, then I can say, and I'm sure Lady Justice Andrews will know this, the club would have just said, oh, blow pay to be paid, we'll support you. The club had the enormous advantage of a completely impecunious member that ran a dreadful ship that poisoned the north coast of Spain and the west coast of France. And that whenever you see charter parties, you see terms, very, very frequent, and I'm sure Lady Justice Andrews will see this, the owners have liability for pollution insurance up to $1 million. No, they jolly well don't if you apply the strict application of the pay-to-be-paid clause. They don't have the right, they don't have liability insurance. What they have is the entitlement, if the club chooses to enforce it, the entitlement to pay a claim and then get reimbursement.
But we all know that there's a particular policy behind the basis for a pay-to-be-paid clause, which won't necessarily arise in cases such as this. It's basically there to stop somebody from taking advantage of the other members of the club.
Indeed.
That's the whole reason it was introduced historically.
Well, that's put quite bluntly, my lady.
Well, I'm trying to save time, but
no, yes, I was junior counsel at a lower stage in the Fanti, so I have some knowledge of it. Yes, it's because of the mutuality of the club, but it's. Don't forget, my lady, that clubs these days regularly reinsure their own liabilities, and those reinsurances are not on a pay-to-be-paid basis. No. So the mutuality argument tends to be embraced within the reinsurances and retrocessions of the club's liability. But it's I think whether it's serendipity, it's the serendipity
that the club had the good fortune to have an impecunious one-ship operator that ran a rubbish ship that poisoned the north coast of Spain and the west coast of France. Whereas the club wouldn't bat an eyelid if it was a Maersk or an Olsen or P&O, DP World. It was the serendipitous characteristic that the liability insurance which the owners were asserting in their charter parties would enable the club actually to get away scot-free from basically paying on an insurance which, had it been a different assured, would have been follow as night follows day. So it's not just a case of here's a poor little insuring club.
It's not all one way.
It's not all one way, no. And so far as the way that P&I clubs work, P&I clubs have pay to pay. They have all sorts of terms which they have the right not to enforce. Let's take, I think, my lord was in a case on a letter of indemnity against discharge against without presentation of a bill of lading some time ago. The fuel something or other, wind. Clubs aren't liable for members who deliver otherwise than against bills of lading, but they have a standard form of wording of indemnity which will then enable them, when the member is big enough and powerful enough, the club will then just go behind the member and will pay or contribute to such liabilities. It's very much is in the discretion of the club. The pay to be paid clause is there partially to enable the discretion so that the clubs will pay when their members are big and not pay when their members are small.
Good. Well, we will resume then with all this at 2 o'clock.
My lord, I have to say I've not made much progress on my submissions, but I hope we've...
Well, I think we've got a picture.
Court rise in favour.